Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And today, we're going to talk about this felony streaming copyright proposal that has been put into the omnibus spending bill that everybody is out there complaining about right now. And they should. They should complain about the omnibus spending bill and the stimulus package that was thrown in. By and large, it's anemic in the face of what has been going on, but that is a topic for some other discussion. This is focused on the felony streaming copyright proposal of Thom Tillis. And this has been getting some critical acclaim, critical recognition, I guess. People saying, hey, you're gonna make it a felony to stream copyrighted material. What implications does this have for YouTube people, for Twitch streamers, stuff like that? This seems to be a bit too far. And I think it actually is a bit too far. I think that this may have the best of intentions. It doesn't. May have the best of intentions, but the practical reality is the language on the page does not support those best intentions and does leave itself open for abuse by an overzealous federal prosecutor who might be responding to complaints from an individual or a company or organization that has lots and lots of money, which is exactly how this nonsense got put into the bill in the first place. But let's read this public statement from Shiva Stella about this felony streaming copyright proposal, and then let's compare it to the wording in the bill. I think that might be very helpful so people can actually see what's going on. Stick with me. I'm going to try and do this very thoroughly, but also very quickly so this video isn't forever long. All right. So today, Senator Thom Tillis released a draft of a felony streaming provision that he has proposed for inclusion in the continuing resolution must pass government spending bill. His proposal would attach felony penalties to commercial platforms which are dedicated exclusively to streaming unlicensed works. That's not in the bill. I'm jumping ahead. Have no commercially significant purpose or use other than streaming unlicensed works or are marketed as such. The following can be attributed to Meredith Rose, Senior Policy Counsel. Quote, as a general matter, we do not see the need for further criminal penalties for copyright infringement. Full stop. That's when you shouldn't write the bill. If there's not a general need for further criminal penalties for copyright infringement, don't put the bill in. Don't pass the law. There's no need for it. Don't do it. And this is one of the main problems we have with Congress. They have to put something. We have to pass some law. No, you don't. No, you don't. If you don't have a need for it, don't pass the law. However, this bill is narrowly tailored and avoids criminalizing users who may do nothing more than click on a link or upload a file. Again, no, it doesn't. It doesn't actually do that in any specific way. There are ways you can argue that it might, that you might have a defense for it, that you didn't intentionally do it. Those are defenses. Those are defenses that the defendant has the burden to overcome. Or, well, I guess technically the state has the burden to prove the intent, but the defense has the burden of refuting that proof. It also does not criminalize streamers who may include unlicensed works as part of their streams. Again, where is this in the bill? It's not in the language of the text, which you will see in a minute. We appreciate Senator Tillis' decision to release the text of his proposal and his leadership in bringing consumer groups to the table. They're not consumer groups. Listening to our concerns and working to prevent risk to end users and legitimate streamers and streaming platforms. They haven't done that in any way. It's really frustrating to see that. But let's take a look at the bill. Now, I have a couple things here. We have the bill. We have that. And we're going to talk about what is actually going on here in the functional aspect of the bill as well as the language of the text, because both of those are very important. And I'm going to show you something right now as we get into the definitions of this thing. I have the definitions. Every definition that is referenced in this document is right here. So you can check out those definitions. You can pause it here. You can return back to it. That will be available for you, okay? All right. So, Section 1, short title. So this is amending Title 18 of the U.S. Code, which is criminal, the criminal section of the U.S. Code. Copyright is actually under Title 17. This is Title 18. This is in the criminal section. This act may be cited as the Protecting Lawful Streaming Act of 2020. This does nothing to protect lawful streaming. Again, the naming of bills in Congress is ridiculous. This has nothing about protecting lawful streaming in any sort of way. It's merely a little nod and a wink to people so that they are lulled, I guess, into security about what this bill does. This is entirely about punishing unlawful streaming and zero about protecting lawful streaming. So find the lie. It's in line 4 and 5. There you go. We've now completed Find the Lie. Section 2, illicit digital transmission services. So they're amending Chapter 113 of Title 18 U.S. Code by inserting after Section 2319B the following. And that is to create an entirely new section, 2319C. This is important because in statutory construction and in statutory interpretation, you typically look at a section as a whole unless there is a reference to some other thing. And they do that right away. So the definitions in this section, they have some definitions set out. Number 1 is referencing the definition section of Title 17, Section 101, which is right here. Again, here are all of them. I went through Title 17, Section 101, and I pulled out each one of those definitions that are listed. So I'm not going to read through the definitions or the things or the referencing section. It's all right there. You can pause it and take a look at it if you want. Okay, so that we have the new definition now. Because again, this is the definition section. Section 1 are these old definitions. Here's the new definition. The term digital transmission service means a service that has the primary purpose of publicly performing works by digital transmission, which is great, except service isn't a defined term in this section or in Title 17. In fact, I don't see where service is a defined term at all in U.S. Code, other than referring to literal military service in completely unrelated sections and chapters of the code. So maybe I'm missing something, but I've been looking and I have not been finding where service is defined in this statute. So that means that service has sort of a common understanding definition. So what is that? Service has a lot of definitions. So I don't know. And this is the ambiguity that leads to problems in the language and problems with the statutory interpretation, and why it's so dangerous, because a prosecutor could suggest that a service is a recurring show on YouTube or Twitch. They could determine that Twitch or YouTube are the services, or that a place like Pirate Bay is a service. I mean, all of those could fit the definition of a service. We don't know. There's no limiting language to it. There's no concretely defined term of what a service is in the context of this bill, in the context of the referenced sections of the U.S. Code. The term publicly perform and public performance refer to the exclusive rights of a copyright owner under paragraphs 4 and 6 of Section 106 of Title 17, as limited by Sections 107 through 122 of Title 17. The long and short of publicly perform and public performance are basically a performance which includes a playing. Like, you're obviously, if you recorded something and then you're playing the recording, you're not performing it yourself per se. Like, it's not a live dramatic reenactment. A performance is the display of the work in public, either through doing a literal recitation or recreation, or by displaying a recording that exists. The term work being prepared for commercial public performance means a computer program, a musical work, a motion picture, or other audiovisual work, or a sound recording, if at the time of unauthorized public performance, the copyright owner has a reasonable expectation of public performance. But look, I'm going to stop reading this. This section only applies to the elevated penalty status at the end. So this isn't super important, but basically what this all summarizes down to is these, and I'll leave it up here. I'm also going to put a link to the bill in the description of this video. But what this summarizes down to is that if there is a work that is unreleased but being prepared for commercial release, right? Like you get a review copy of a movie or a video game or something like that, that you know is about to come out, and then you release it and you stream it, that is an escalated felony. It is not the main punishment. It is the escalation of the felony. It is an aggravating factor. So that's all it comes down to. But basically, yeah, if a movie has been made but not publicly commercially released, you get an enhanced penalty. But if it's been commercially released, you get the regular penalty. So that is very important to remember, that that's the only place that that definition is referenced, and we'll get there. So the Prohibited Act, it shall be unlawful to willfully and for purposes of commercial advantage or private financial gain offer or provide to the public a digital transmission service that, okay, so to gain money by providing to the public a digital transmission service, which, remember, that's defined right up here as a digital transmission service, a service that has the primary purpose of publicly performing works by digital transmission. By the way, a YouTube show very likely falls under that, because I'm providing, like right now, this is the primary purpose of this show is to publicly perform a work by digital transmission. The work is just mine. I'm not taking someone else's, but I'm digitally transmitting to you a work that I have created. So just so you know, that's how easy it is to define a digital transmission service. And it is not limited to something like Pirate Bay, which is a website dedicated entirely to providing unlawful or unlicensed works to you digitally. That's completely separate. Both of those things fall into the category of a digital transmission service that is primarily designed or provided for the purpose of publicly performing works protected under Title 17 by means of a digital transmission without the authority of the copyright owner or the law. So here's a distinguishing point. They have to show that the service is primarily designed to do this. Now, how they go about arguing that is, again, an argument. What does primarily designed do? Well, what if you produce a lot of YouTube content, for example, but the stuff that makes you the most money is the stuff that involves the streaming of copyrighted works? What about, think of MXR, right? MXR Plays or whatever, the YouTube channel. Almost all of their content is related to the digital transmission of works protected under Title 17, created by others, and they do it without the authority of the copyright owner. Their argument is a fair use argument under the law. That's it. That's their shield. Is merely an argument, a legal argument that is fact and case specific. So while they likely in many cases have a right to go ahead and retransmit the work of others by adding their commentary, so long as that commentary or the review of the work is sufficiently transformative, they have to make that argument. But their digital transmission service, their YouTube show, is primarily designed for performing works that are protected under Title 17 without the authority of the copyright owner. They're just, hopefully have the authority of the law. Has no commercially significant purpose or use other than to publicly perform works protected under Title 17 by means of a digital transmission without the authority or copyright owner or the law, which again, I believe that's their entire commercially significant purpose. Is intentionally marketed by or at the direction of that person to promote its use in publicly performing works protected under Title 17 by means of a digital transmission without the authority of the copyright owner or the law. Every live react video series is this. All of them. If you're reacting to the work of someone else, that's this entire section, unless you get explicit permission from the person whose work you're reacting to or from the publication you're reacting to, you fall into 1, 2, and 3 if you're doing it for money. That's it. That's it. That's what a reaction video service or reaction video channel actually is doing. And so that is the danger, again, of this bill. It does not in any way offer a specific protection for lawful streaming services. There are some mitigating things, like, again, you can say, well, under the law, under fair use, I have the authority to do this. But that's you on the defensive. That's you having to justify your actions through a very specific application of rules that is entirely subjective and is entirely individually fact specific. Imagine if you get prosecuted for this under with 100 videos and having to defend each one of them individually on a case-by-case basis in criminal court. The amount of money you would have to spend to do this is off the charts. So penalties. So that's it. That's the violation of the law. I hope you guys caught that. This is the Prohibited Act. It's to provide to the public a digital transmission service that does 1, 2, and 3. That's it. That's the entire thing. That's illegal. Now we get to the penalties for that. Any person who violates subsection B shall be, in addition to any penalty provided or found under Title 17 or any other law. So you've got other sections of 18 for criminal purposes, and then under Title 17 you have civil remedies for this, of course. 1, fined under this title, imprisoned not more than 3 years, or both. Just not more than 3 years, though. So it's just a felony if you do it. Number 2, shall be fined under this title, imprisoned not more than 5 years or both, if the offense was committed in connection with one or more works being prepared for commercial public performance, if the person knew or should have known that the work was being prepared for commercial public performance. So that's where we go back to that spot at the beginning where it defines what being prepared for a commercial public performance is, and that's entirely limited to this subheading, number 2, which is the escalated felony of up to 5 years in prison, and presumably a higher fine. But that is if you're releasing an unreleased movie. For example, you're streaming digitally an unreleased movie without authorization. Boom, 5 years in prison. And then number 3, shall be fined under this title, imprisoned not more than 10 years or both if the offense is a second or subsequent offense under this section or section 2319A. So there you go. That is that's the further aggravating factor. So nothing in this section shall be construed to, quote, affect the interpretation of any other provision of civil copyright law, including the limitations of liability set forth in 512 of Title 17 or principles of secondary liability, or prevent any federal or state authority from enforcing cable theft. And this just adds 2319C, illicit digital transmission services, to the actual table of contents for the U.S. Code. That's it. There's the whole bill. That's what it does. So if anyone is out there telling you that this bill could make the unlawful streaming of copyrighted property into a felony, yes, it can. If they're telling you that it won't apply or can't apply to Twitch or YouTube channels, or legitimate, whatever a legitimate streamer is, they can't actually make that promise. It's not in the language of the bill. Now, it may get there, right? The courts may interpret it that way in the long run, but without having a defined term of what a service is, then just about everybody who ever goes ahead and creates videos or some other work that streams copyrighted work without the express permission of the owner is now subject merely to a defense of fair use. And a fair use defense is very strong. And there's lots of, I don't want to undersell that, right? There is a lot of case law about what fair use is. The problem is, do you want to be in federal felony criminal court defending your creation of a video? No. And there's nothing in this bill that limits it to specific websites or any sort of thing like that, or even gives us analogs to what that service looks like. So it could apply to individuals. And anyone telling you otherwise, frankly, I would love to see their citations. They may hopefully and convincingly argue that it doesn't apply. but it's not in the language of the text, and that's the important part, because if it's not in the language of the bill, then a zealous prosecutor with maybe some sort of interest, like in going after a high-profile personality, can go ahead and file charges under the bill, and then that person has to defend it. And even if they win, they lose. Because I tell you, you don't want to pay to defend yourself in federal court for a felony. It's very, very expensive. And it's not something that anyone should be subject to unless it's absolutely necessary. This bill's a disaster. Everything about it's wrong. The omnibus spending bill is a disaster. And I want to point out, remembering this, as a general matter, we do not see the need for further criminal penalties for copyright infringement. Then why do it? Then why do it? Then why does it exist? I should clarify, I don't believe that this came from Tom Tillis's office. I don't believe that this came from Tom Tillis's office, but then if we don't have a need for it, we shouldn't do it. And we shouldn't excuse them for doing it either, okay? That shouldn't be an excuse. Well, it is narrowly tailored. It's not narrowly tailored. I don't think it does anything that they say in here in any specific way other than leaving some arguments for your defense. I don't want to be arguing to defend myself in federal criminal court personally, but that's it. I hope you found this informative. I hope it was useful. Again, links to the article and the bill are in the description, so check them out if you want to read it for yourself. Yeah, other than that, have a good day. Peace. Peace.